YouTube. This video stems from a viewer's question I received last week. Do passengers in vehicles that are stopped by the police have to show identification when asked to do so by the police? Please, if you have any questions you would like answered in a future video, jump down in the comments below, and you never know, we might answer your question in a future video. Also, if you like this video and would like to see more videos like this one, please subscribe to our channel. Now let's dive right into today's question. Do passengers in a vehicle have to show their ID when asked by a police officer? After hearing a case from Arizona, one of the western states under its jurisdiction, the Ninth Circuit U.S. Court of Appeals ruled in January 2019 that police cannot extend a traffic stop if a passenger refuses to present a police officer identification. The decision came as a consequence of an appeal of a criminal conviction filed by the passenger Aflredo Landeros, who was in the front passenger seat of a car stopped early in the morning near Pascual Yaqui Indian Reservation, southwest of Tucson, for driving 11 miles faster than the posted speed limit. Officer Clinton Baker detected the odor of alcohol and observed two females in the back seat who he believed were underage and in violation of the reservation's 10 p.m. curfew. The two women, aged 19 and 21, handed over their identification when asked to by Officer Baker. Landeros continually refused to produce identification to the police during the encounter. Drivers are obligated by law to present their driver's license, car registration, and proof of insurance when pulled over for a traffic violation. According to Baker, it was common procedure when they pulled a vehicle over to identify everyone in the vehicle. The decision of the Appellate Court. The judges in the Federal Appellate Court debated whether authorities can legitimately ask a passenger to present identification and whether police can continue a traffic stop if a passenger refuses to do so. Regardless of whether the first request for Landeros' identity was legal or not, law enforcement's reluctance to take no for an answer from Mr. Landeros was not, said U.S. Appellate Circuit Judge Marcia Berzon in the court's judgment. However, if an officer has a reasonable suspicion that a passenger has broken the law or is about to break the law, the officer can demand that the passenger present identification. Because of Landeros' rejection, the appellate court found that the officer lacked the necessary reasonable suspicion that the officer had violated Landeros' Fourth Amendment rights to be free from unreasonable search and seizures. As a result, evidence gathered during the traffic stop should not have been entered during Landeros' trial, including 6 bullets discovered in his pocket during a consented search. He couldn't have bullets because of a past felony conviction on his record. Landeros' refusal to ID did not, according to the court, constitute a failure to comply with an officer's legal order under Arizona Revised Statute 28-622A. According to the court, the officer's decision to extend the traffic stop by calling for backup was not reasonable. In contrast, prosecutors put forth the argument that Officer Baker had a reasonable suspicion because he smelt alcohol and the backseat occupants could be breaking the curfew. The prosecution did concede that the police did not believe Landeros was under the age of 18. The court stated that knowing Landeros' name would not have made the police any safer and would have prolonged the traffic stop longer than required, putting the officer's safety at risk. For law enforcement officers, traffic stops are inherently risky. They have no notion if they are about to enter a potentially dangerous situation. Reasonable suspicions fundamentals. The United States Supreme Court has approved the use of reasonable suspicion as a law enforcement tactic. It authorizes officers to make a traffic stop and detain someone for a short period of time if they have grounds to think that the individual is planning, trying, or committing a crime based solely on the officer's training and expertise. Reasonable suspicion is defined by the United States Supreme Court as a kind of common sense judgment about human behavior on which practical people are entitled to depend. Reasonable suspicion demands more than an unarticulated hunch, according to the courts. For example, if police are monitoring a high crime area and they observe someone fleeing, for example, reasonable suspicion is aroused and the police can stop said individual. What should I do if I'm pulled over by the cops? While the appellate court's decision upholds the freedom of persons who aren't driving to ignore an officer's request for identification, it's always a good course of action to be kind and respectful to the officer when exercising your right to not identify to them. You now know that as a passenger you are not required to show your identification, but you must not interfere with the police, and if at all possible, you shouldn't even speak during the entire interaction. If you're driving and are stopped by the police, it's lawful and highly recommended that you don't answer any of the officer's questions. That's because whatever you say to the police becomes evidence, which the state can and will use against you. Simply inform the police that you are exercising your Miranda rights, which date back to a 1960s Arizona case, and provide you with the right to remain silent. When you are being interrogated, you also have the right to have an attorney present. So inform the police you would like to speak to an attorney. Well, I hope you enjoyed today's video, and if you would like to see more content like this one, please subscribe to our channel. Thank you for watching YouTube, and until next time, stay safe out there.